Oh, good morning, everyone, and welcome to another edition of Friday Morning Live. Your host, Dave Newell, here running up from Tallahassee. We'll bring in our special guest, Scott Johnson, here in a moment, but we're excited everybody has joined us this morning for a topic that I know is on a lot of agents' mind and certainly occupies a lot of time and energy here within FAIA, the Florida property market, and what agents need to know. So we'll get into a lot of this in a minute, but you see my picture there, so we'll bring in Scott in a second. And then the next slide that you should see talks about today's topics. A few weeks ago, Amy O'Connor with the Insurance Journal did a two-part series on the crisis of the Florida property market. We posted on our website in the community. And we're going to reference some of that because Scott helped participate in these articles. Our new CEO, Kyle Ulrich, was quoted here a few times. And with others talking about the property market and a potential legislative fix. So we'll drill down through some of these articles today. But more importantly, Scott has a presentation that he's done a couple times, most recently with the during the insurance summit for the Florida Chamber that will really enlighten and highlight several of the issues that are driving some of the property rates in Florida. So we'll get into that in a minute. Just want to remind everybody that FAI education continues to have web-based learning. That's the schedule for the next week or so. I know the holiday is fast approaching with Thanksgiving, but if you're in a need for some education, professional development training, we have you covered here at FAI. So get on our website and certainly go over to the education page and you can get those. We continue to run the academies. Currently just finishing up the 220 Academy. That's for those agents that have a 440 that would like to convert their license to a 220. And those academies have been very successful. Received 2 more notices yesterday, Scott, from agents that have completed those academies and have actually passed the state exam on their first attempt.
Wow.
Which we remind everybody, those that are taking the state exam for the first time, the pass-fail rate is less than 50%. So we feel very good about our academies and preparing you to sit for that state exam, and certainly the people that have responded to us and have told us that they've taken the exam and passed it, we have a real good track record right now.
Well, that's good.
So the next one is certainly the 2044 Academy. Those for those agents that strictly handle personal lines, and you would like to convert your license to an all lines personal lines 2044 license, we have that academy available. And so that's running, and certainly both of these academies, Scott, are also on demand. So if you want to do these classes at your leisure, or as I say, take them at 3 o'clock in the morning, it's there for the taking. So certainly take a look at that. And again, it's another option. We're not going to probably continue under the governor's emergency order forever. So this would allow you the ability, both having your 220 or your 2044, to work remotely without an emergency order. So upcoming shows, still working on that for after the holidays, but we'll see how that goes. But again, as we bring in Scott Johnson, I'm going to talk about a few things here. This particular Friday Morning Live is approved for CE. You will get an hour of CE if you comply with a couple things that we have to do throughout the broadcast. The first one being when we do an attendance check and I ask you to do certain things in your question pane, please provide that information in your question pane. And at the very end of today's broadcast, I'm going to ask you to type in a statement. And I'm going to say this: I, Dave Newell, certify my attendance. So that is required for us in order to give you CE for this particular class, or really any webinar. So at the end of the broadcast, I'll announce that again and ask you to type in that statement, and we'll validate your attendance here today, and then we will provide CE to your transcript through the Department of Financial Services. So, good morning, Scott Johnson.
Good morning, Dave. Thank you for all of that. I've got a lot of information here for you. Some of it's a little disturbing about the fraud that's going on in the marketplace and what's driving that. So we're going to get right into it. First thing I'll go over with you is some of the numbers that Dave talked about, the players who are involved in some of the shenanigans. We'll look at a case study, in fact, of the Strems disbarment trial, which is very, very instructive as to the root causes and what's going on at the street level out there. We'll talk about what agents need to do to report fraud and how and so forth. And then at the end, I've got kind of a message. I talked with a couple of insurance company CEOs who wanted me to share some information with agents. It's a little bit different, and we'll cover that at the end, along with some other takeaways. So it kind of starts for me when I'm looking at the numbers in the marketplace with this particular chart. People ask, what happens when insurance companies are losing money? Well, this is a very good illustration of that. If you look at you'll see that descending blue line starts in 2015, and that's when the insurance companies, according to this blue line, were making somewhere in the neighborhood of $400 million or so. And then it descends through 2019 to a negative number. And you'll notice that the orange line in this is almost the reverse mirror image of the blue line. And those are the rate increases that took place the year after the drop in the particular year for that particular blue line. So it shows that basically, and where the line is dotted, that's the add-in for reinsurance. The rates are also rising in reinsurance. That's more not very good news. But you'll see that that's what happens when insurance companies are losing money. The OIR has to follow the law and approve appropriate rate requests, and they do that. And the result is as you see there. Specifically, there are some trends going on in the marketplace that are driving that. We're just going to look at 1, 4, and 5 here, highlighted in white. Property lawsuits, they doubled from 2017 to 2019, basically from 45,000 lawsuits to 92,000. And since 2015, which was the beginning of that chart I just showed you, lawsuits have increased 400%. Number 4, litigated claims. That's the lawsuits we just talked about, are 5 times more costly than unlitigated claims. And finally, as I mentioned, reinsurance is up in some cases 35% just in 2020 alone. So how does this affect the bottom line? I think numbers 3 and 4 here sum it up the best. The industry's combined ratio in 2019 was 111%. That means that for every dollar that came in the front door, $1.11 went out the back door. That was last year. And for this year, through the second quarter, it's already up to 129%. Dollar comes in the front door, $1.30 goes out the back door. Ladies and gentlemen, there's only one word for that, and that's unsustainable. Yep. We can't keep going in that direction. The market will collapse in some form or another. So what do carriers do when this situation is impacting their bottom line? Well, first thing they do, not necessarily the first thing, but one of the things that is the most publicly obvious is they ask for rate increases somewhere, and they all are. There are a few that didn't, but somewhere between 20 and 40%. One company asked for 47% and still wanted to get off 25,000 policies. Also, I think it's important to note that the solo counties, Seminole, Orange, Lake, and Osceola counties, for the first time at least as far as I know, the rates are rising. They are higher than the statewide average, sometimes, depending on the carrier and the risk, 65%. And carriers are also doing the other things that we all know about, cutting back on coverages and non-renewals. One agency was canceled in one of the most egregious examples and had 7,000 policies with one company. So these are all the things that, and I'm told from an underwriting standpoint that you can't find coverage in the private market for a home that's 300,000 or less and over 10 years of age. And that means one thing: Citizens is populating again. And when I say Citizens is populating, it's taking off like a SpaceX rocket here. Yep. There's 3,000 new applications every 5 business days coming to Citizens. That's 3,000 a week, 12,000 a month, 144,000 in 12 months. If it doesn't increase from where the last report was. Well, before we look at what's driving all of this, I want to take a look at a basic insurance axiom we all learned about in Insurance 101. It's called a moral hazard. You understand that that's when a bad insurance policy or program motivates people to act badly or engage in fraudulent behavior. That's why we have things like insurable interest. You can't insure somebody's home if you don't have an insurable interest in it. Otherwise, you'd go burn it down. Well, there's 2 types of moral hazards. Skip down to number 3. One is the individual, like I just described, and the other is a collective moral hazard, usually the result of political or irresponsible public policies that motivate bad behavior in others by virtue of their existence. Good example: the legislature passed a prohibition against the replacement cost holdback. Replacement cost without the holdback is a moral hazard because you can get new for old. Yep. But insurance contracts allow the payment of the replacement cost to be held back until you actually perform the replacement. They prohibited that by law. And what happened? Next year, loss costs went up 65%. So they repealed that prohibition, and everything's okay at this particular point. But that's what a moral hazard is, a collective moral hazard. Now, in the state of Florida, speaking of moral hazards, we have a couple of concepts with respect to attorney fees that are very important for us to understand, because I believe it is what's driving the fact that we have double the lawsuits and 5 times the severity in attorney fees. First thing that happens, you'll see this in red at the top of this chart, after every lawsuit, whether it goes to a jury or it's settled, there's a separate hearing that the judge conducts to determine the awarding of attorney fees. In most states, the concept is a prevailing party gets their attorney fees paid for. In Florida, however, we have what's called the one-way attorney fee statute. And in those situations, the insurer, if they win, they do not get their fees paid for. So a major disincentive is removed from filing a frivolous lawsuit. And just anecdotally, the AOB reforms last year proved that that's true, because the major piece of that legislation was to reform the one-way attorney fee statute as it applies to AOB cases. What happened? AOBs are now down by 47 to 57%, depending on the carrier. The suits are way down. And so that proves that the one-way attorney fee disincentive is very important in driving some of the litigation that we're seeing. But there's also something in Florida called the attorney fee multiplier. It exists in other states, right, but it's applied differently here. Sometimes in a lawsuit, the aggrieved party may have difficulty finding an attorney willing to take on the lawsuit. Perhaps it's a particularly complicated case or maybe it's a contingency type situation in which if they lose, the attorney gets nothing. And so in this hearing, after any lawsuit, the judge is reviewing things, and he or she will normally use what's called the lodestar methodology for calculating the attorney fees that would be awarded under the one-way attorney fee statute. And so, for example, the lodestar calculation is what we would all think it is. It's a reasonable hourly rate times a reasonable number of hours. You got 10 hours and you charge $100 an hour, you get $1,000.
Right.
But as I said, sometimes a case is very complicated and the aggrieved party can't attract an attorney to take it on. So the idea of multiplying that fee as a way to motivate people to take on motivate an attorney to take on the case came into being. Now, this concept exists in every state. The Supreme Court of the United States, however, frowns on the concept unless it is applied in a rare and exceptional basis. And that is the standard across the entire United States and was the standard in the state of Florida until 2017. In the case Joyce versus Federated, the lodestar methodology, or actually the fee multiplier, was applied in a case that was anything but rare and exceptional. And in fact, the Chief Justice of Florida Supreme Court at the time, Charles Kennedy, said it only took one phone call to find the attorney who was willing to take this case.
Exactly.
And so what you then have really is the worst possible scenario as far as I'm concerned. For example, here are some fee multipliers. Since then, the request for fee multipliers in cases is applying to just virtually every case it's being asked for.
Right.
Doesn't have to be rare and exceptional. Doesn't have to be a difficult case. Perfect example, Santiago versus Florida Peninsula. It was a plumbing leak where the final award was $41,000. The attorneys got $1,201,670 because the judge doubled their fee under the fee multiplier case. In Despande versus Universal, they doubled the fee for a $23,000 loss, and the attorneys got $415,000. Now, I'll tell you this, last week, the third DCA overturned this particular award, so that's a good sign, and the implications of it are it's a little premature at this time, but it does show that the awarding of the fee multiplier is out of whack. Even the third DCA agreed with that. Exactly. In Pedrero versus Citizens, $35,000 loss. The total attorney's fees were $702,000, if you can imagine that. Now, look at this next chart. Still on fee multipliers. This is from Citizens. Skip to the far right-hand column. The percentage of the fee award versus the indemnity paid, 491%. The attorneys got 491% more than the indemnity paid to the policyholder. Keep going down that line. You'll see 1,070%, 2,036%, 1,079%. The severity is off the charts, and in my opinion, the moral hazard is undeniable that is created by the attorney fee statutes working in tandem with each other. It's kind of like, the old stick and carrot thing. The stick was the one-way attorney fee statute. They no longer have to worry about that stick. They don't have to worry about paying the other side, and it's been replaced by a carrot, luring them to use the attorney fee statute, right, to get the fee multiplier going. So with that in mind, let's take a look at this next chart, which is something I put together kind of as a reality check, a reality litigation check. here in Florida. Number one, attorney fees can be a moral hazard. And I submit to you in Florida they are. Now, one thing that's very interesting in this is an attorney, well, or those plaintiffs' attorneys anyway, were saying all last year during the AOB hearings, well, if insurance companies would just pay their claims, we wouldn't have to sue. Well, time and time again, it was demonstrated that insurers are not acting any differently or handling claims any differently. Our very good insurance commissioner, David Altmeyer, testified to that time and again during the AOB hearings last year. They keep very sophisticated complaint records and complaint ratios. They follow up on every consumer complaint, and there is no indication that insurance companies are handling their claims any differently from the way they always have. The next thing that's kind of telltale in all of this is the first notice of losses that are going to insurance companies. I listened, for example, to the Capital Preferred rate hearing, where they were asking for 47%. It was later reduced to 36%, I believe. And Jimmy Graganella, the CEO, testified under oath that 26% of their first notice of loss comes in with an attorney representing the policyholder. In other words, nobody called a 1-800 number. Nobody filled out an FNOL form and sent it in. An agent wasn't contacted. And that means in those situations that an attorney and a policyholder got together to sue an insurance company before it was physically possible to know that they even had to sue the insurance company.
Right.
For all they knew, Capital Preferred was going to pay the claims and do so generously, if for no other reason than to avoid frivolous litigation. So those two things taken together, insurance companies aren't doing anything different. FNOLs are coming in, first notice of loss as a lawsuit, is a prima facie case that something is bad, wrong, and that it's the litigation that is driving the increased lawsuits and not the behavior of insurance companies. The reason they're notifying the company of a lawsuit first is because they want the attorney fees to start running before the insurance company has a chance to pay the claim. The impact, by the way, of all of this isn't just the amounts of frequency and severity. 5 times the cost of a litigated claims and the doubling of lawsuits. It's also the 800-pound gorilla in every negotiation. Insurance companies are presented basically with a kind of a Hobson's choice. Hobson is a guy who owned a livery stable in the 1800s in New York City, and he would put all his old hags up front, all his old broken down horses, and that's the ones you had to rent. If you couldn't, it was either take that or nothing else. Right. And that's what insurance companies are faced with here. It's settle now on our terms, or face the possibility of much worse when the fee multiplier kicks in and the one-way statute says you've got to pay it. I mentioned that we were going to look at a case study, and we are. It is we're going to look at several of them. This is the Strims Law Firm study. Disbarment trial that just took place this year, and it was very instructive from the standpoint of what's going on in the marketplace. Now, this first came to my attention in 2017. I was writing a series of articles called Bad Apples, and it was about the behavior of some attorneys. And the DFS, Department of Financial Services, sent me 14 letters. They were transmittal letters notifying them of lawsuits that were being filed through their service of process databank. And I picked up on 448 suits in 8 months that were filed by the same firm, and 78 of those lawsuits were concurrent, meaning that the same policyholder sued the same insurance company for losses occurring at the same address on the same policy. and they did it on the same date. The only thing that was different was the date of loss. And I was told that that doesn't happen anywhere else except at this one law firm. Over the course of 2 years, I found that in this case, it was Strims, had filed 2,057 suits, and 223 of them were concurrent, with as many as 4 lawsuits per homeowner or per location filed on that basis. The allegation, of course, is that they have concurrent attorney fees running on all of those cases. Well, now let's jump ahead to 2020, and the Supreme Court suspends on an emergency basis at the request of the Florida Bar Association Scott Strims' license to practice law. And in a trial ensues. He's found guilty of 11 Bar Association ethical rule violations, and is sentenced to 2 years suspension and 1 year's worth of supervised probation of his license. But the trial revealed that his firm was handling at a time often 10,000 cases, 10,000 lawsuits. Some of the attorneys with the firm had 750 cases each themselves that they were handling. And testimony by 2 sitting judges at the trial was that in virtually every case, the firm or its lawyers were violating rules of ethical conduct in the handling of each one of those. I urge you, when you get through listening to me yammer on here, go to my website and read the series of articles titled Collapse of an Evil Empire, parts 1 through 7, and probably more to come, because it's very instructive as to what's going on in the marketplace. But I listened to all the hearings for 3 weeks of this case. I read over 1,200 pages of documentation. I listened to all of the examinations under oath, or the transcripts of them, and I came up with some takeaways from this case that I think you will find is exactly what's going on in the marketplace on a too often basis in the state of Florida. Number one, attorneys are sharing attorney fees with non-attorneys in violation of the Florida Bar Association's ethical rules of conduct. Number two, so-called loss consultants are performing the same functions as public adjusters, but doing so without a license. We'll talk a little bit more about that in a minute. Homeowners who often don't speak English are signing tablets by public adjusters, like an iPad, that have contingency agreements for attorneys in them that the homeowners didn't know about for damage that they often didn't even know they had. In a specific allegation in the case, a public adjuster called on someone 2 years ago. She signed the iPad. 18 months later, she gets a check for X number of dollars and discovers that the attorney had been hired and had sued the insurance company and got over $100,000 in attorney fees. So she's approached again by the same public adjuster to do it all over again, which she did. And by the way, had concurrent lawsuits in both situations. But she specifically requests that I don't want to file a suit. I don't want to have the Strims law firm represent me. And guess what? It happens anyway, because she has signed that iPad. And so there is now an allegation in a lawsuit against the Strims firm for that. But that is partially how you get to 10,000 lawsuits in order that caused his license to be ultimately suspended, or one of the transgressions. Number four, PAs are transforming into loss consultants to violate statutory fee caps. what happens is the PA in this case, in the example I just gave, later becomes a loss consultant on behalf of the attorney firm. And instead of getting just 10% of the indemnity paid to the policyholder, he gets 10 or 20% of the full global settlement, including attorney fees paid to the attorney firm. So instead of 10% of $10,000, he's getting 10% of over $100,000. That's by way of example. Number 5, public adjusters, both licensed and unlicensed, are inflating losses by 20% in violation of state law. Now, some of you are hearing me say that and going, well, duh. But in this particular case, one of the allegations in this case was when Strims hired a public adjuster who had just gotten out of prison for committing mortgage fraud and was out on work release, no longer had a public adjuster's license, but he acted as a loss consultant and did an estimate on one loss and confessed. It said under oath, I inflated that estimate by 20%, acting like, I guess, that it was normal for that to happen. Of course, public adjusters don't do that. The good ones don't. But this guy did, and leads me to believe that others are doing the same. Number 6, attorneys are using subterfuge to extend litigation to increase their fees. Again, this comes to me from the Stims trial and testimony. And finally, number 7, attorneys are dividing global settlements among themselves, of course, and those who work in the firm. They're loss consultants and public adjusters, as I just said, but not their own clients, who are getting paid only the indemnity in that case. And that's fine. I'm sure there's a legal foundation for it, but it doesn't make it right. And I have shared information on my website about a plaintiff attorney and others, a plaintiff's attorney, who are complaining about public adjusters coming to their office and offering to bring them hundreds of claims in exchange for the attorney agreeing to only accept a global settlement from the insurance company, so that the claim payment isn't just the indemnity. Right. The claim payment is therefore, hundreds of thousands of dollars, including attorney fees, and they can get their 10 or 20% of that instead. So when I say that attorney fees and attorney fee statutes can be a moral hazard, that is the perfect example of a collective moral hazard that results from poorly designed attorney fee applications.
Yeah, Scott, just a quick second. I know some of you've lost your question pane to respond to my initial attendance check. So right now, it looks like everybody's on the line. Go ahead. And do you prefer to fry or bake your turkey? Just type in fry or baked, and that's your second attendance check. Here we go. Look at them all. I think bake is leading the charge, Scott. Okay. So, all right, go ahead. Sorry.
All right. Good. So let's just keep that in mind. Those are my personal takeaways from the Strims hearings. And let's look at some case studies. I want to do this because I want you to begin to see how that stick and carrot that I referred to motivates activities and how it filters down to the street level behavior that you as agents are seeing out there and that your policyholders are being subjected to for water remediators, roofers, public adjusters, build back contractors, and so forth. So first, let's take a look at the water remediation issue. I want to stress this before we move forward, because assignment of benefits in the state of Florida is still legal. But water remediation is not regulated in the state of Florida. Of all of the entities I just mentioned, attorneys and plumbers and roofers and so forth, and contractors, water remediators are the only ones that are not regulated. Perfect example. this woman whose picture does not appear here, but her name was Angie. She was arrested for insurance fraud while she was working for an insurance agent, and had embezzled 191 checks from that insurance agency. I pulled her FDLE criminal report, and it was 47 pages long. The agency had hired her because they thought she had turned over a new leaf. And when I pulled her corporate records from the Secretary of State, I found out at the time that she owned 5 different water firms, water remediation firms, and her brother owned a whole bunch more. And later, I found out she owned 8. And today, she probably owns even more. The day after she was arrested, by the way, she's out on bail, and she files another AOB lawsuit the very next day. So there is no regulation, no license, no statutory rules of conduct for water remediation firms. And as an insurance agent, you need to be extremely diligent in doing, and proactive in keeping your clients from hiring firms that operate and use AOB. Number one, it's not illegal. It's just a big, huge red flag. And keep in mind, there are people like this out there who shouldn't be allowed near a home, much less inside of it, to do the important work of water extraction. Okay. Now, we're going to look at some of the statutes that apply to the cases I'm going to show to you. First of all, this is the public adjuster statute. Read with me, if you will, in paragraph 19, the underlined portions. No person except an attorney at law or a public adjuster may, for money, commission, or any other thing of value, directly or indirectly, A, prepare, complete, or file an insurance claim for an insured. B, act on behalf of or aid an insured or third-party claimant in negotiating or effecting a settlement. And D, solicit a claim on behalf of a public adjuster, an insured, or a third-party claimant. That's the public adjuster statute. Keep that in mind and look at this lesser-known statute. It's called instigation of litigation. And the first paragraph starts with whoever gives, and the second paragraph starts with whoever in any way solicits. Okay? Let's read the first one together, the underlined portions. Whoever gives, promises, offers any valuable thing whatsoever with the intent and purpose of stirring up strife and litigation, skip down, shall be guilty. Look at paragraph number 2. Whoever in any way solicits, receives, or accepts any valuable thing whatsoever, any promise, contract, agreement with the intent or purpose of stirring up strife and litigation, shall be guilty. These are the laws that may not always want to be prosecuted by a local state's attorney,
Right.
but are nonetheless being broken and generally because of the handing down or the passing down, if you will, of the attorney fee statute, the stick and the carrot that I mentioned earlier. So let's take a look at how this manifests itself at the street level. Here is a bus, an alert agent, I think in Sarasota, took a picture of this. And let's look closely at what is advertised on the side of that bus. The sign says, waterdamagesucks.com. And by the way, that URL does not work. So, I tried. I went www.waterdamagesucks, and it didn't work. But the quote there is, my ice maker line burst, and the young lady is saying, I got $35,000 to remodel. Now, first of all, that lady there holding that sign, she didn't get $35,000 for anything. That's just a picture you get off the internet, and you can put out whatever message you want on that sign that you want. But why did they say my ice maker line burst? Well, first of all, an ice maker line holds cool, clear, clean water. it doesn't make a mess. That's why they didn't say, imagine that your house is covered with a bunch of raw sewage, because they're trying to induce you to do something, namely, to pull your ice maker line out, have a little cool, clear, clean water spill on your kitchen floor, so that you can get what? Get your kitchen floor repaired? No, so you can get a brand new kitchen for $35,000. They are suborning the commission of insurance fraud on the side of a bus. Why are they doing that? Because they know there's a big payoff in there, and that ultimately the insurance company is going to have to pay when they get sued, and they're going to get sued because of the attorney fee statutes I just shared with you. Here's another example. This, I believe this was right after Hurricane Michael.
It was.
And right there, remember the two statutes we just looked at? This roofer is advertising, we fight denied claims. Well, that's all well and good as long as he has a license as a public adjuster or he is an attorney. And why an attorney would be driving around in that truck right there, a roofing truck, I don't know. So that would be a violation of the law. Just remember the part we read in the statute said solicit. He's soliciting by using that particular terminology there. This actually picture might have been taken by a public adjuster, a good one, who didn't like the fact that someone was public adjusting without a license. Here's another one. This is a business card. Look what it says in the lower right-hand corner. This is a roofing company, Insurance Adjuster Specialist. I don't even know what that means, but I don't think it's legal unless you have a license. We work with your insurance to get you a full roof, not partial or not patched. You better have a license if you're representing people in that fashion.
Hey, Scott, stop you there. So you gave 3 examples. What can agents do when they see these types of things in their communities?
Well, that's, if I can ask to just defer that a little bit, because that is exactly what this, I was contacted by a few folks who wanted me to share what they think agents could do. Other than just reporting it, which they certainly should do. Remember, we also talked about in one of those statutes, the financial inducements.
Right.
Well, look at this, $10,000 referral fee. Why would anybody pay $10,000 for a darn phone call? Because they know they're going to be able to get it back when they sue the insurance company later on. Look at this next one. Here is, this was from Hurricane Sally. This just happened. Illegal deductible rebating. It's a felony to pay the deductible for somebody or to induce them to avoid paying that deductible. Here it is written on a yard sign. It's bad enough that they do it, but that they're dumb enough to put it on a sign and stick it in somebody's front yard and say 0 deductible insurance claims. It is just a prima facie case that things are really bad in Florida's marketplace when it comes to litigation and fraud in the property marketplace. Now, this is a fast-talking son of a gun right here. And I'm going to play a video, and I'm going to tell you that it's kind of startling at first because he bangs $20,000 on the tabletop right in front of the microphone. But listen to the message that he shares, and remember those statutes we just talked about.
Hey, what's going on? This is Juan, and if you are a homeowner in South Florida, and if you have any type of home damage, whether it's water, mold, mildew, maybe you have a damage in your roof, it doesn't really matter, any type of home damage. Today, I want to share with you a little secret that your insurance company does not want you to know. Now,
First of all, that's not true. Your insurance company does want you to know that they will pay your claims in full. That's how they sell policies.
Right.
So you'll hear him say just the opposite here. Just
the reason why I have these $20,000 here in my hands. And also I have just over $90,000 here worth of insurance checks. You'll be able to see them here on the screen. I have one for 11,500, 12,381, 18,000, another one for 18,000, and another one for 19,000. So what your insurance company doesn't want you to know is that if you have a damage in your home, the insurance company is actually responsible to pay you every single dollar that you need to be able to fix that damage and repair your home just like it was before the damage happened. All right, we are actually professionals, and as you can see, we are very good at what we do. We help homeowners, we represent them. We have a team of professionals that...
Stop right there. What did he say? We represent them. Well, that's all well and good, but you better have a public adjuster's license or be an attorney in order to do that, to represent them against an insurance company in order to get their claims paid.
Actually goes to your home at no cost, gives you a free inspection, and if you are interested in moving forward, we can help you get all the money that you need from your insurance company so that you can put your home back together without having to pay out of pocket. All right, so go ahead, click on this video, reach out to us, talk to you soon.
Okay, now watch this next short video. This, I believe, was actually video recorded by an alert insurance agent on August 5th in Orlando, just recently. Across the street, you'll notice this guy is on a roof. He's inspecting a perfectly good roof, and he's prying up the shingles on the roof, intentionally breaking the seal, using a tool that we'll show you in a minute. You can see him right there. See, he's pulling the ceiling, the roof tiles up to create damage. He's got a tool in his hand, and in a minute he'll walk away. That's the tool, or the one that looks just like what he's holding. There he is. You can see he's walking around. He's king of the hill here. He's got his tool. He's looking for more tiles to rip off, and definitely not a tool that you need to just conduct a roof inspection. He's knocked on the door, like many of your policyholders are getting knocks on their doors. You can see that tool going underneath the tile right there in that particular instance. And this is so typical of what's going on when somebody knocks on a door and wants to get on a roof. Heck, there are recorded instances of these types of roofers using duct tape to tape marbles to the bottom of their shoes so that when they walk around on the roof, they create simulated hail damage. Or they take dimes and they twist the dimes on the tile, spinning them around and creating hail damage while they're up there. And SIU investigators can find this out pretty easily because guess what? There's never hail damage that's near the edge of the roof. It's always up in the center where it's safer for these guys to walk around. So in summary, the one-way attorney fee statute and the fee multiplier represent the perversion of the old adage of the stick and the carrot. And they are combining to create a moral hazard that exists uniquely in the state of Florida and nowhere else, with double the number of litigated claims and increase in severity of claims because they were litigated of somewhere in the neighborhood of 500%. Again, part of the problem is in prosecuting these claims. People don't want to get interviewed by a prosecutor or an investigator. They're reluctant to share information, and prosecutors are too busy. They're handling all these other, murders and armed robberies and stuff, and little insurance fraud where insurance companies have to pay is not high on their list. But I've been contacted by some insurance company CEOs who wanted to share with me, and in these videos that you've just seen, a lot of these were the result of insurance agents or their employees. These guys are knocking on doors where you live in most cases. And there's three things that people do when they get knocked on the door. Let's say it's an agency CSR. Somebody knocked on their door. Number one, they know it's a scam and they slam the door. Number two, they don't know it's a scam and they get sucked in And they let the guy on their roof. And Dave, you just told me somebody, agency principal, his mother-in-law, something like that, had signed an AOB.
Absolutely.
And was worried about what to do about it. We'll talk about that in just a second. And the third kind of person who answers the door to one of these scammers is engages them in a conversation.
Right.
Gets copies of their work orders, gets their business card, asks them who else in the neighborhood had they promised a free roof to. In the case of a roofer doing it, it might be a public adjuster or a build-back contractor or a water firm that has knocked on the door. And if that information can be given to an insurance company, and has been in several cases, and the insurance company has come to the agency, sat down with a policyholder who had experienced something bad with a particular third-party vendor, and they wrap it up in a nice bow and put it in a package, and they take it to the state's attorney's office, who is delighted to have a case put together where they can actually prosecute insurance fraud. Now, the Division of Insurance Fraud at the CFO's office they are some of the hardest, most intelligent investigators in the world, and they are doing a great job, but they don't prosecute. They only can investigate and hope that a prosecutor will take the case. This is one way to get prosecutors to prosecute insurance fraud if it can be wrapped up and presented to them in this fashion. There are a number of companies out there who are engaging in that activity with willing agents, and you may see some cases break here in the next several weeks that will show you exactly what I'm talking about. So keep that in mind, and let's look at some important takeaways for agents. This goes to your question that you asked me earlier, Dave. Some important takeaways from all of this. Number one, for agents, don't use or refer any entity that uses assignment of benefits. It's legal, but it isn't. It's a major red flag that something could be wrong. There's never a need to do that. There's always somebody else out there who will do the same work without using an assignment of benefit. Number two, policyholders, tell your clients, do not sign anything until you've reported the claim, and always be suspicious of anyone who knocks on your door. 3, report fraud. There's the myfloridacfo.com website where you can go and it tells you how to do it, or you can call the 1-800 number. They will follow up. I've done it numerous times. The CFO's office is extremely competent at doing that and getting legitimate claims brought to the attention of the Division of Insurance Fraud. Number 4, do not recommend or refer public adjusters. I'm sorry, but I've had a discussion with one or two agents who said, no, I sometimes do that because my policyholders, they can get 20% more for their claim. Well, yeah, but they've got to pay the public adjuster with that 20% more. And besides, I can tell you this, that if an insurance company finds out you're doing that, they're going to cancel your agency contract. And the reason is because the very act of referring a public adjuster prejudices the insurance company's case should the claim ever be controverted. Think about it. You, as the agent, are the insurance company, and you're telling the client you haven't gotten paid enough. A plaintiff's attorney would have a great time with you, putting you on the stand for that. Purge your lists. I know that some of you provide lists to policyholders. You're careful to say, we don't endorse these people and we don't recommend them, but here's some numbers you could call if you wanted to get your water remediated or your roof fixed or whatever. Well, keep in mind, you may say you're not referring anybody, but you could still be held liable. You gave them the number to call and a bad result took place. So make sure if you have lists like that you don't have anybody on there who's one of the water firms I talked to you about earlier, or who uses AOB and so forth. Be proactive as agents, like the insurance company CEOs had told me to mention here. There are plenty of brochures that you can email to your clients about the kinds of fraud that's taking place. It's available from DFS, the OIR, FAIA. Dave, I think, has some stuff on its website. You can download those brochures and zip them out to your clients, because it's, keeping water losses and stuff like that down goes straight to improving your loss ratio as well.
Absolutely.
And remember, here's the key thing. With AOB, two things occurred that made all the difference. Number one, they reformed the one-way attorney fee statute for AOB. And number two, everybody has 30 days to cancel any AOB that they might have signed. So, yeah.
Scott, repeat that again, because I think that's what, when we had Hurricane Michael, I think that came up a lot, where people thought they were still locked in indefinitely after inadvertently on that particular one. She signed that contract and didn't realize she signed it and thought she was locked in. We had to update that agent and his mother-in-law. No, you do have an out.
Yeah.
So repeat that again.
Well,
Scott.
that's what's, as long as it was signed after the effective date of last year's statute.
Right. It was.
Then there's no question that all they have to do is notify that third-party vendor, whoever it was, that they want out of it in writing, and it's a done deal. This is what has, one of the things that has caused AOBs to be about half of what they used to be.
Right.
Because they know people can get out of them, and before the insurance, when they contact their insurance company or their agent, the insurance company or agent is going to remind them of that.
Yep.
So keep that in mind, and have no qualms about making that recommendation. And last, number 8 takeaway here is train your staff and your coworkers. No referral fees, no AOBs, no excuses. And when I say no referral fees, there was an agent early last year who had his agency contract canceled. This was in South Florida, because one of his CSRs had recommended a water firm that was one of the bad firms. And the company found out about it and terminated the agency contract. Principal goes in to remind his CSRs not to take referral fees, and finds out they'd all been taking $1,500 referral fees from water firms.
Wow.
And that were bad water firms. And this is the kind of moral hazard, and how it comes down from attorney fees and reaches the street level. You have plumbers out there who, before AOB was reformed, were making $35,000 a year in referral fees, non-taxed referral fees paid to them by water firms. So be careful. No referral fees, no AOBs, no excuses. And Dave, that concludes my presentation.
Well, before we let you go, Scott, as you throw up the next slide. Okay, folks, everybody has been responding. Some not thinking they're responding, but you have been responsive in your question pane. So we've come to the end of the presentation. So in order to get CE for today, we've done the 2 attendance checks. And the last thing you need to do is to type in the question pane, and everybody's been doing it. I, and your name, certify my attendance. I, in my case, Dave Newell, certifies my attendance. You have to type that in your question pane. So, like in this case, I, Jordan, or I, Thomas Jones, certify my attendance. You type that in your question pane. Everybody's been doing it when I've asked the previous 2 questions. So, Scott, can you hear me?
Yeah, okay, I can hear you fine.
Okay, I'm not seeing anybody type. So, again, this is...
Well, I can hear you here in the room.
Yeah, well, you... So... Well, then you repeat it then. Apparently, nobody's responding to me.
Okay, well, if you can hear me out there, what Dave was saying that...
You can hear me? Okay.
Yeah, okay. Well, it's confirmed. Everybody can hear, so be sure and type that in.
Yeah, because we want to give everybody CE. We think it was a great presentation. a lot of good information, a lot of great takeaways, Scott, that I think agents can take. And that was part of our conversation of you and I putting this together, is really explaining the issue, but also doing some takeaways that agents can help with staff and educate their clientele, their policy holders.
Right. And if anybody has questions or what, because there's a lot here that we didn't have time to share, please feel free to email me at scott@johnsonstrategiesllc.com. Ask your questions. If you would like a copy of this presentation, email me. I can. It was too large to put on my website, but I have it stored at box.com where large documents can be stored. If you'll email me, I can download that to you, and you can use it. It's written. It was laid out the way it was laid out so that people could use it to make their own presentations if they wanted to. If you have to talk to a local Rotary group or something like that. And please go to my website and become a subscriber. It's free. It'll help my Google rankings, which will help get the word out on some of these issues as well.
And then lastly, before we say the end of this presentation, we want to thank Scott. Scott was with us at FAI almost 40 years. Certainly has done a lot for us during those years, but certainly since then as an outside consultant, is really honed in on this and has done many presentations. So we're thankful to Scott to really stay on top of this. He arms FAI staff with a lot of information that we can use to help agents and help consumers, because we do get consumer calls, and we try to guide people in the right direction. So thanks again, Scott, for this great information.
My pleasure.
Thanks for all those in attendance today. I see you're popping in that I certified my attendance today, so that's a good thing. We'll get all that handled. And then lastly, Scott, we got a lot of questions, that we couldn't get to today. So here's what we're going to do, folks. We're going to get Scott all of those questions. He will take his time and diligently provide answers to each one. We will make sure the entire group will see all the answers, okay? So I know there was a handful of people that were asking questions, but we want everybody to share in those responses. So give us a little time. We'll get all those questions to Scott. He'll form his answers, and we'll get it out to the group. So just bear that in mind, and it may be a day or two with Thanksgiving next week. But, Scott really works 24/7, so he may have it done by tomorrow afternoon. Just kidding. But, no, thanks again, folks. Thanks for being on Friday Morning Live. We appreciate your membership in FAIA. If you have any questions or concerns, please let us know. We did record this session. It will be on our website, and Scott talked about his website as well. So you won't get CE for it, but certainly the information will be valuable to you and your staff as you talk about these issues and why it's so important, Scott, to keep informing the public of what's happening and what's driving rates.
Yeah.
So, but thanks again, folks. Dave Newell signing off. Have a great weekend. Happy Thanksgiving, and be safe out there.